Mr. Chapman.
Thank you, Chairman Dermott, Ranking Member Grassley, and the members of the committee. And thank you for the chance to testify about the treatment of student loans in bankruptcy. As has been mentioned, an often overlooked component of the higher education financial landscape. Okay, my name is Christopher Chapman, and I'm the CEO of Access Lex Institute. We're a nonprofit organization with a membership comprised of the nearly 200 state-assisted and nonprofit law schools approved by the American Bar Association. Access Lex applies its resources to expand access to law school while working to increase its affordability for the value increase its affordability and value for the benefit of aspiring lawyers and ultimately the society they'll serve. As has been mentioned, reform of the bankruptcy process is necessary to address the negative consequences resulting from what is effectively a judicial failure to adapt to legislative changes over the last 30 years. By effectively remaining static in spite of those legislative changes, the test for undue hardship has morphed from what could be arguably an appropriate basis for analysis and application of the law to an overly strict and uneven exercise, even for those small percentage of people who successfully navigate the procedural hurdles, which serves to frustrate the underlying goals of both the Bankruptcy Code and the Higher Education Act. So I'm pleased to offer a proposal today that we've been pushing for almost 7 or 8 years that appropriately balances the important interest implicated by the discharge of student debt in bankruptcy. It is a little different than the Fresh Start proposal that I just heard about this morning, but it's offered in the same spirit. In other words, to fix a problem that exists, that doesn't have to exist, and can be remedied in fairly simple legislative ways. We've long advocated for responsible borrowing, offered quality counseling, and encouraged diligent and timely repayment at Access Lex Institute. To that end, we offer many extensive financial education programs for our member schools and our member students, beginning with pre-law and going all the way through repayment. These services include our Max Financial Education program and the ability to talk with accredited financial counselors one-on-one. We believe it's a great model for what others can do more broadly in the higher education sector. However, we also recognize that access-driven student loan programs will necessarily produce some borrowers who are unable to pay, often for no reason of their own. And until we have a working crystal ball, defaults in the student loan program, and in some cases bankruptcies, are a necessary cost of maximizing the intellectual capital of this country. In our view, there are 3 core factors which must be properly calibrated to maximize the efficacy of the substantial investment in higher education by the various stakeholders and the value to the country as a whole. First, the provision of equal and affordable opportunities for all who pursue higher education, which forms the basis of the Higher Education Act. Next, the ability for the honest but unfortunate debtor to obtain a fresh start, while also promoting equitable treatment of creditors, representing the core tenets of the Bankruptcy Code. And finally, the ready availability of capital to allow Americans to reliably and affordably pursue their education dreams, a factor equally applicable to both the government as a lender and private sector lenders. So in this spirit, we propose a return to the framework that existed prior to the 1998 amendments with one substantive addition. Specifically, we propose that undue hardship standard remain, but only for loans which either first enter repayment within the 7-year period preceding the applicable bankruptcy filing, or loans which, without regard to time and repayment, are eligible to participate in an income-driven repayment plan, providing for monthly payments no greater than 15% of discretionary income, with loan forgiveness available for a period no longer than 25 years. All other student loans will be evaluated in bankruptcy proceedings consistent with other consumer debt. In addition, we strongly encourage Congress to revisit the definition itself of undue hardship. Congress has never defined this term, and the judiciary's attempts have resulted in an unduly strict standard that is unevenly applied, only exacerbated by the elimination of the limited waiting period in which it was applied. For example, creating clear guidelines for the minimum standard of living and establishing safe harbors for certain types of expenses in the analysis, like caring for a sick parent, could help rationalize the undue hardship analysis with the realities of today's borrowers, who have larger loan balances and longer repayment periods than those of prior decades. In sum, we believe our proposal effectively balances the interest of all parties involved to support a vibrant loan structure that encourages opportunity, access, affordability, and personal responsibility, all set against appropriate and acceptable capital risk for the private sector and taxpayers alike. Thank you very much for listening. I'm happy to answer any questions that you may have today, or as the committee works to advance these efforts at student loan reform in the future. Thank you.